You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 37, How to Get Foreign Patents in Non-PCT Countries. My name is Dr. Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or if that's too hard to remember, you can get to it through patentingforinventors.com, that's patenting, F-O-R, inventors.com, or you can call me at 424-281-0162. And while most attorneys can only practice in states where they're members of that state's bar, patent attorneys are actually allowed to practice patent law in any state, so feel free to contact me regardless of where you live. So far in the last several episodes, I've talked about PCT international applications, what they are, how they differ from U.S. applications, how to file them, and the major deadlines associated with them. If you remember, the PCT application is a single application that can be used to enter various foreign countries. But these countries generally all have to have signed on to a specific treaty called the Patent Cooperation Treaty in order for you to use the Patent Cooperation Treaty application. Now, most major industrialized countries have signed on to the PCT, but there are a few major ones that haven't. Taiwan is probably the most important one from a business point of view, but there are lots of others that you should be aware of, and I'm going to go over these situations. Now, even though a country may not be a member of the PCT, it doesn't mean that you can't use the PCT application or your own U.S. application to serve as a priority application. So it's not like you have to file in non-PCT countries all at the same time in order to get patent protection. Remember that the whole point of using an earlier application called a priority application when filing a PCT or other application is that normally a patent examiner can reject your application using any reference that was public before your application filing date. If you're filing in a foreign country, even your U.S. application can be used against you in a rejection of your foreign application. But the exception is that when you file your foreign applications, you can claim priority to your earlier U.S. or PCT application, which means that the foreign examiner can't use any reference that occurred before your U.S. or PCT filing date. So what do you do if you want to file in a foreign country and they're not a member of the Patent Cooperation Treaty? Does that mean that your own earlier application will be used against your foreign application? In general, the answer is no. And this is because there's another treaty besides the PCT that some countries have signed on to, where you can use your earlier application as a priority application, and this treaty is called the Paris Convention. If a country is part of the Paris Convention, then you can use your U.S. application or PCT application to serve as a priority. The major difference you need to be aware of between PCT countries and Paris Convention countries is that you only have 12 months and not 30 months to file your foreign applications. I talked about those deadlines in the last episode, so go back to that episode to understand the national application deadlines. Now, a country can be both part of the PCT and Paris Convention, but once a country joins the PCT, it doesn't really matter if it's part of the Paris Convention anymore for deadline purposes because you have the 30-month deadline. Countries keep joining the PCT, so you always want to find an updated list, but at the last count in August 2018, there were 152 PCT countries. Jordan was the last one to join in 2017. Of the countries that are not part of the PCT, but are part of the Paris Convention, there are about 26 countries. And I'm just going to read those off, so if you hear one of these countries and you're interested in patent protection, make sure you're aware of the 12-month mark when you file your PCT application or your U.S. application, whichever you filed first, because you only have 12 months to file in these countries based on the earliest application. These countries are Afghanistan, Andorra, Argentina, the Bahamas, Bangladesh, Bhutan, Bolivia, Burundi, Democratic Republic of Congo, Guyana, Haiti, Iraq, Jamaica, Lebanon, Macau, Mauritius, Nepal, Pakistan, Paraguay, Samoa, Suriname, Tonga, Uruguay, Vatican City, Venezuela, and Yemen. This might not be the entire list because sometimes there's some issues on whether a territory is a separate country, but it might count as a country. But these are the standard ones that are listed as being Paris Convention countries that are not PCT countries. So maybe you caught that I didn't say Taiwan yet because Taiwan is not a Paris Convention country or a PCT country. There's another way that you can be allowed to file a patent in another country claiming priority to your U.S. application or PCT application, whichever is filed first, within 12 months. And that's if the country just decides that it will let you. The U.S. may have a bilateral treaty with that country, or the country, even though it hasn't signed on to the Paris Convention, just says that we're going to let you claim priority to your U.S. or PCT application. There are about 9 countries that have done this, And these are Cape Verde, Ethiopia, Fiji, Kiribati, Nauru, Solomon Islands, Taiwan, Tuvalu, and Vanuatu. Except for Taiwan, most likely you're not going to be that interested in getting patent protection in these countries. It's not like you don't want patent protection in every country, but every country costs money. And I've never had a client come up to me and say, I really want to get a patent in the Solomon Islands, and here's $10,000. And then there are the countries where you're just out of luck for patent protection, either because they don't really have a patent office, so there is no patent protection, or there's no way to claim priority to your earlier application. And there are about 9 countries that in reality, you probably don't care that much about trying to get patent protection in, but I'm going to tell you them anyways. It's East Timor, Eritrea, Maldives, Marshall Islands, Micronesia, Myanmar, Palau, South Sudan, and Somalia. Again, these generally aren't countries that most people are interested in getting patent protection in because the cost benefit just isn't there. You should always take a look at the current list of countries. Just do a search on WIPO for PCT countries or Paris Convention countries, and you should find a current table. There are special situations in certain parts of the world like Hong Kong, where technically it's not covered by a Chinese patent and technically not part of the PCT or Paris Convention. But if you file a Chinese application or European application and designated the UK, you can basically just do some paperwork and then get a Hong Kong patent once one of those have issued. So how do you get patent protection in these non-PCT countries? Basically the same way you enter the national stage from a PCT application, except that you have to do it within 12 months and not 30 months. You contact a patent attorney in those countries and ask what it takes to get a patent based on your earlier application. There are some companies that serve as a hub for you, so you can tell a single company what countries you want protection in, and they do all the legwork in finding attorneys in each country to file your application. It's a lot easier to do that than try to search out patent attorneys in countries throughout the world, because these companies that serve as a hub have already established relationships with attorneys throughout the world, and they know what's required in each country. If you have a U.S. attorney, and you really should have an attorney if you're thinking about international patent protection at all, then your U.S. attorney should be the one doing all this for you. So the gist of it is that most countries throughout the world, currently 152 countries, you'll have at least 30 months from your U.S. filing date to nationalize your PCT application. If your country's on the list of PCT countries, if your country is not on the list of PCT countries, then you'll have 12 months from filing your U.S. application for the 35 countries that I've mentioned, which are about 26 Paris Convention countries and 9 countries where there's some special arrangement where it's still allowed to file an application there based on an earlier application. Then there are the 9 countries where you can't file based on your earlier application, and some of them don't even have patents at all. And practically speaking, you're probably not interested in those countries either. If you want help with drafting your patent application, you can contact me through my website at patentingforinventors.com. That's patenting, F-O-R, inventors.com. Or call Diamond Patent Law at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patenting, F-O-R, inventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.